So for this episode, I want to depart for the time being from my discussions on the Proverbs. And I want to discuss the Magna Carta in detail, going through its various clauses. This is something that I have been studying as a secondary. I've been going through the history of England, and I've read a book recently on the Magna Carta, and I've reached the appendix for which the Magna Carta is outlined. So I want to start with a brief history of this Magna Carta. This document, this charter, originally came about in the 13th century under the rule of King John in England, reigning 1199 to 1216. He was seen as a tyrannical ruler in part, rather ineffectual. Heavy taxation, failed military campaigns, the loss of Normandy to France, alienating the nobility class. King John had conflicts with the church. He was excommunicated by Pope Innocent III, which had an effect on his overall standing. By 1215, the resentment by the barons, which is a class of the nobility, reached a point, a culmination that could not be held back any further. They were upset by the king's arbitrary justice and financial demands. Many barons, they formed armed rebellion and demanded reforms to limit the powers of King John. The barons captured London, forcing King John into negotiations. On June 15th, 1215, at Runnymede, King John agreed to the barons' demands and sealed the Magna Carta. Initially, the charter was a failure, annulled by Pope Innocent III shortly after it was sealed. The Pope declared it invalid. This led to the First Barons' War, 1215 to 1217, between John and the rebels. After King John had died in 1216, his son Henry III reissued the Magna Carta to gain support, baronial support. Over time, it was reaffirmed by successive monarchs, becoming a cornerstone of English constitutional law. It played a major part in the Glorious Revolution of 1688 and the general or gradual succession in the exchange of ideas between the position of power in English society, whether it be the supreme power within the position of the king or of the aristocracy, or in the parliament, or within the supremacy of law, within the supremacy of precedent and common law. The Magna Carta played a part in all of these deliberations. It was used on the part of conservatives and also on the part of liberals, a dynamic document that served to comment on a very large cultural and political development of one of the most successful, powerful societies that the world has ever known, at least had come to be that way. Over time, in the 19th century and in the 20th century, the influence of the Magna Carta had begun to wane, and that was partly due to advancements in political thought, perhaps some positive and some negative. There were efforts to reduce the bloat that had occurred due to the accumulation of statutes, and in the process of repealing these statutes and developing committees that would have that responsibility, the Magna Carta and many of its clauses, were reduced or repealed because either they were not practical or they had some historical meaning, but in the modern context there really was no precedent for them. But at this time, I want to put all of that aside and evaluate each one of these clauses as it is, and try to find myself in the headspace of the context in which it was written. Often there is this reference to the spirit within historical proceedings. In the American context, the spirit of liberty. In the English context, I suppose the spirit of liberty would still be appropriate there, but certainly the spirit of the Magna Carta. And despite having the majority of its clauses removed, the impact and the general, again, spirit, which is this sort of broader theme, a form, an idea, that it was originally meant to convey something at a particular point in time under a particular set of relationships and constraints that I think can be applicable to all ages. Although we would have to do some thinking and some work to place it appropriately within the constraints and the context of the modern age. So there is an introductory paragraph here that I'd like to read that is beginning in this appendix. So Magna Carta, 1297. The following text is taken from Statutes at Large, edition O. Roughhead Revised C. Runnington, 1786 to 1800. I. 1 through 10. Edward, by the grace of God, King of England, Lord of Ireland, and Duke of Guyenne, and archbishops, bishops, etc., we have seen the great charter of the Lord Henry, sometimes King of England, our father, of the liberties of England, in these words: Henry, by the grace of God, King of England, Lord of Ireland, Duke of Normandy and Guyenne, Earl of Anjou, to all archbishops, bishops, abbots, priors, earls, barons, sheriffs, provosts, officers, and to all the bailiffs, and other our faithful subjects, which shall see this present charter, greeting. Know ye that we, unto the honor of Almighty God, and for the salvation of the souls of our progenitors and successors, kings of England, to the advancement of Holy Church, and amendment of our realm, of our mere and free will, have given and granted to all archbishops, bishops, abbots, priors, earls, barons, and to all free men of this our realm these liberties following, to be kept in our kingdom of England forever. So beginning here with the first clause, Cap 1, a confirmation of liberties. First, we have granted to God, and by this our present charter have confirmed, for us and our heirs forever, that the Church of England shall be free, and shall have her whole rights and liberties inviolable. 2. We have granted also, and given to all the free men of our realm, for us and our heirs forever, these liberties underwritten, to have and to hold to them and their heirs of us and our heirs forever. So after each one of these, I'll give some thoughts and reflection. You know, there is talk of vagueness within law as something that is not admissible in argument, that if something is too vague, then its standing, again from a principled and argumentative standpoint, will be quite minimal, and the probability of having a clause repealed or limited in some way is higher. And I'd like to bring in, again, this argument of spirit. I think sometimes broad constraints are better than the desire to destroy or to reduce a constraint because of its vagueness. So I'm going to go through this line by line. It's my rather tedious way of doing things. First, keeping in mind this is titled A Confirmation of Our Liberties. A statement meant to confirm, or, in the words of Google, to establish the truth or correctness of something previously believed, suspected, or feared to be the case. So beginning with the first line, saying, "First, we have granted to God." Quite an interesting beginning. I find it quite hard to believe that if any major legal precedent were to be set today, that it would begin with a surrender, a grant, a submission to God, or to some power that is beyond us. Now, of course, what is being spoken of here is the liberties of the church. So that makes sense that it would start this way. But there's a significance, being that this is the first clause. This is at the top of mind. This is of principal attention. If I were to sit down and do something, I wonder, or if I was going to outline something, work on some creative project, I suppose there's an element in me that would want to save the best for last, but also there would be an anxious part of me that would want to get out an important expression. It's something that I just need to make sure is solidified, is codified, so that it is not forgotten. And so I think that the significance of this, the confirmation of liberties, the first clause, the first sentence, "First we have granted to God," is quite telling about the English mind and the sensibilities of the time. "And by this our present charter have confirmed, for us and our heirs forever." For us being the barons, that class of nobility in the English day, keeping in mind that this is written within the milieu, within that context of the feudal governing structure. This hierarchical structure of governance and landholding developed in the wake of the Norman conquest of 1066. In the time of King John, the feudal system was characterized by a rigid chain of relationships and obligations. These obligations tied the monarch to his subjects through land and loyalty. Now, in terms of the monarch, This was the apex of that feudal pyramid. He held ultimate authority. Now there's aspects of this that aren't quite right, because throughout English history there is this tension between papal sovereignty and the sovereignty of the king or the monarch. And in addition, the barons, the noble classes, always held some position of authority. They had some influence over the king's authority, power. Moreover, the king in his relationship to other principalities. So, for example, the relationship of the king to the King of France influenced his power as well. But nonetheless, in the general context, the king claimed divine right to rule. This was something that was believed to be sanctioned by God. If not the individual, at least the position of the king. The king, in theory, or hypothetically, owned all of the land, distributed it to his vassals in return for loyalty, military service, financial support. The responsibilities of the king were oversight of justice and law, management of national defense and warfare, collection of taxes and feudal dues. The class immediately below him, the barons and the nobility. The barons were called these tenants-in-chief, were the king's direct vassals and formed the upper tier of that nobility class. As mentioned, their obligations to the king were military service. The barons were required to provide knights and soldiers when they were called upon, financial duties in form of the payment of taxes, scutage, which is contributions of money in exchange or in lieu of military service, and for ransoms in case the king was captured, which indeed did happen. They served an advisory role. They were expected to advise the king in his royal council. But as mentioned, the barons had significant power. They were often semi-autonomous rulers within their territories. And there's a broader conversation here that I think should be mentioned about the liberties that were enjoyed by the English prior to the Norman conquest. In the days of the Anglo-Saxon kings of England. Anglo-Saxons being tribes that came over to England that kicked out the Britons, who were, I believe, another Germanic tribe that had come earlier. And they established a society there. It was quasi-feudal in a way. There was more of a chieftain and warrior society, so there was more liberties in that respect. Sort of a crude society, as one can imagine. Below the class of barons, we have the knights and lesser nobles. The knights were the vassals of the barons. They held smaller parcels of land called manors in exchange for loyalty and, again, military service. Their obligations were kind of similar to the barons in terms of their obligations to the king. The king's obligation to the barons were to serve them in military campaigns, defend the barons' estates, and enforce local law and order, participate in feudal courts as judges or jurors. The class below the knights and inferior nobility were the peasants and serfs. These were the people that worked the land. Among this class of people we had free men. Some peasants were free, rented land from their lords, paying rent and providing specific services. The serfs, which comprised the majority, they were bound to the land and to the lord. They could not leave the manor without permission. Their responsibilities were to provide labor to the lord, to pay rents in the form of crops, livestock, other goods, perform other services as repairing roads, making fortifications. In return, they were given protection and the right to live and work on the land. The church is another important aspect of this feudal structure. It ran parallel to the feudal society. Bishops and abbots were major landholders, similar to barons, and owed feudal duties to the king. And throughout English history, as I mentioned, there was this tension between where the sovereignty actually rests, whether it be within the seat of the Catholic Church in Rome, or whether it be to the king. The church wielded spiritual authority over all classes, including the king, as well as economic power through tithes and land holdings. In terms of the administration of law, local governance was carried out by sheriffs appointed by the king. They collected taxes, managed lands, enforced the king's justice. The feudal courts had multiple levels to them. We had the manorial courts, which handled disputes among peasants. The baronial courts addressed issues among knights and tenants. Royal courts, the king's courts, addressed serious crimes, disputes involving the crown, or appeals from lower courts. And all of this, again, in the day of King John, was met with increasing attempts to centralize authority into that position of the king. And this strained relationships through that heavy taxation and arbitrary justice. The king had many failed military campaigns, and that alienated his vassals. Ultimately, a lot of this led up to the creation of the Magna Carta, again in 1215. So to return now to what we were discussing. First, we have granted to God, and by this our present charter have confirmed, for us and our heirs forever, that the Church of England shall be free, and shall have her whole rights and liberties inviolable. So here we run into this potential dilemma, for which the courts throughout the centuries have pointed out, that of the difficulty of defining certain things. What does it mean to be free? What does it mean for an institution to have her whole rights and liberties inviolable? As I mentioned, there are arguments that because something is vague, makes it, in a sense, indefensible, where it needs to be reduced in terms of its authority. It's something that needs to be clarified and defined, and perhaps that's true. But as I've mentioned also, that the spirit of liberty, and that of what is considered to be free, is something that appears to the minds of man differently depending on the context, depending on the age, depending on the constraints. But I myself understand the argument that if something is vague, it'll only get us so far, and we have to do the work to actually understand and give a definition to what free means, or to have her whole rights and liberties defined. And here I'm reminded of our Bill of Rights, a document that outlines the inviolable rights of the citizens, but again is not really meant to be exhaustible. And so there is this idea that despite declaration and the explicit nature of rights, there are ways of coming to understanding that which is true and that which is true among a free person or persons that cannot be limited to a certain set list. We cannot statute our way to liberation or to freedom. It is again something that it's conditional to a degree, in the sense that our will is conditional, but we still have a freedom of will. Now I can will, or have the desire to fly, and I may jump off the 4th floor of a building, and it doesn't necessarily mean I'll fly, even though I have the desire to. There are certain constraints that are afforded by the conditions that we find ourselves in that limit our action and what we wish to do. But just because this is the case doesn't mean that we are not free. Of course, there's a big difference between wanting to be liberated from the physical constraints of natural law and wanting to be free from arbitrary constraints of some man-made institution. So if we ask ourselves, well, in what way was the church not free, or becoming not free, entering into that state? And again, this is something that is contextual. So if we define the word free under the Google definition, it says, not under the control or in the power of another, able to act or be done as one wishes. It's a muddy affair, it would seem, freedom and liberation, because as I've mentioned, with limitations of physical will, there are all sorts of limitations in the cognitive realm as well. Now, it doesn't mean that we arbitrarily give into these things, but every so often there will come a time for which the mind is compelled to submit to something, and it may do so because it feels that it must comply in order to gain some advantage. This rendering of one's liberties in the feudal context at the time may have seemed necessary to the peasants so that they can be protected. Perhaps to some it seemed a gross violation of their personhood, and yet to some others they may not have had any thoughts to the matter at all, and truly have been more of a servile constitution, unfortunately. So thinking in a little bit more detail about this matter, about the constraints that King John was placing on the Church of England, and here I want to keep in mind that there's an overarching goal. We have to establish the relationship of the time between King John and the Church of England, but also what it means for the church to be free, the purpose of the church, and exactly what is being limited by these constraints. So the first of which is competing claims of spiritual and temporal power. Now, these concepts are difficult because now, as we speak of something within man's ability, it would seem that the spiritual realm is really not meant to be controlled, just like the natural realm is not really meant to be controlled. It's something that can be understood, and it can be harnessed in such a way that we can be productive, we can produce things that are beneficial to society, but it is not necessarily something that we control the laws of. We don't produce the laws of physical reality, and we don't produce the laws of spiritual causation, meaning, purpose. We participate in them, and we understand them. We come to understand them. So I think an effective church or an effective spiritual institution is much like that of a secular university, in the sense that it attempts to teach us the principles and the rules by which we come to understand that which is true. It's a observational class of epistemology. Moreover, in spiritual matters, there is a component of subjective experience and also participation. So even within the complaints of the age of King John between the church and the position of the king, I think, at least from my point of view, we should recognize that wherever the power rests, the power, I think, can be corrupted if one believes that the purpose of that power is to control it rather than to facilitate it and to distribute and to invigorate the understanding of it. So the first contextual point here is the disputes over church appointments. King John interfered with the election of church officials, especially the Archbishop of Canterbury. In 1205, upon the death of Archbishop Hubert Walter, a dispute arose over the election of his successor. The monks of Canterbury elected one candidate, while King John supported another. The Pope, Innocent III, rejected both candidates and instead appointed Stephen Langton in 1207, an act of which John refused to accept. So in this way, John's actions violated the Church's traditional right to elect its leaders without royal interference. And this sparked a conflict with the papacy. So a freedom in this sense would be a liberation from the authority of the king to interfere in the institution of that church hierarchy. Now in 1208, after John refused to accept Stephen Langton as Archbishop of Canterbury, the Pope Innocent III placed England under an interdict, which is a censure that suspended religious services and sacraments, including marriages, burials, and Mass across that kingdom. And so there's this spiritual disruption for ordinary people. In 1209, Pope Innocent III excommunicated John, spiritual penalty intended to isolate him from the Christian community. So in response to this, John confiscated church property and wealth, using it as funding for his government and military campaign. The clergy who opposed it faced exile, imprisonment, persecution. The church lost control over its vast estates and resources, undermining that economic independence. weakened the church's ability to resist royal demands and maintain its influence. By 1213, John was facing mounting political and military threats, including the possibility of a French invasion backed by the Pope. John made a concession. He submitted to Pope Innocent III, agreeing to recognize England and Ireland as papal fiefs and pay an annual tribute to Rome. So here we see the power moving to the church. It effectively made John a vassal of the Pope, subordinating the English church and crown to papal authority. So the question of liberty, of sovereignty, it again has its head just as it does among the commons as it does in institutions. In the case of the English church, I find to be a fascinating one because it's one level of argument for some individual autonomy separated from something else. And this balance of the individual as he rotates and articulates against the broader informational landscape, that broader informational landscape that consists of everything that includes him, but also all of the institutions, his relationships, his perceptions, everything about the world and the environment that is separate from him. This articulation is necessary. I think we can imagine perhaps a schematic illustration in which this rebounding or this circular utilization of information and then the branching outward away from the primary source into one's own ideas, thoughts about the way things ought to be or the way one ought to live, or how an institution ought to act independent of some more stabilizing institution, or more centralizing institution, I should say. And I see these varying types of participation, or of, again, articulation that I had mentioned. Of that first sort, the circular, in which there's really only one point of contact, as let's say as a rotating circle comes around, it's attached to some point, but it is only attached to that point at one spot, at one point. As it comes around, it contacts the broader informational landscape. And we can think about this in a matter of scale. So let's say we're talking about an individual. And again, depending on where we choose to place the mind, the perspective, we can say, well, there's something larger than the individual in an organizational standpoint, which we could say is the family. And so this individual articulates with the family. He has this, imagistically, as I mentioned, this circular relationship, that revolving relationship. There's one point of contact that he, as an individual, as an agent, decides or chooses the way in which he participates with the family, the way he behaves, the way he approaches relationships, etc. Or, maybe I should say a couple more things before I go into the or. And I think we can think of the way in which the family articulates with the broader society, or ideally, I think as it should be, more of its local environment, and then to the state and to the nation, that society, Western society, whatever. In our case, in the modern day, I think it's a bit different. It's probably man, family, then internet mind, and then the various other parts of his life that he has. The internet mind has become such a pervasive thing now, and we are all aware of what's happening so quickly. Now, in the sense of the or-ness, what I mean by or, especially when we're talking about, again, that relationship between the individual and the family, we can imagine various different shapes with various numbers, various degrees or points of contact between the broader whole that the individual gets satisfaction, selfhood perhaps from, and himself as a separate agent, the degree to which he can call him separate from it. And I'll say this is more of a proverbial approach to understanding these things, but the individual is not an isolated thing. So I don't mean to make a dualist argument here. The individual is formed by the information from the environment, information that is material but also ideas based. And it is not the case that the individual, as the agent, exists in a vacuum. His will only extends so far. There are constraints placed on it. But within the bounds, within the rules that he is given to operate the conscious mind, the conscious being, he has the ability to change his, let's say, the shape of the way he articulates with the broader thing. Ultimately, the broader thing, especially in the sense of the church, since we're talking about this here, is its articulation to God, to the transcendent, to the divine logos of the universe, whatever. Logos of reality, I think, is a better term to use. So these various shapes, again, I think can provide us with different types of relating. And in a rough and broad sense, I think that the overarching culture has a particular way of producing or affording a certain type of interface. I think religion also helps us with that. I think various people's ideas, of course, help us with that. I think fundamentally, this is the relationship of the individual to its environment. So everything is going to have some influence on it. The more sophisticated things are probably going to have more sophisticated influences. But leaving that aside, adding it to our broader picture, going back to this idea of having multiple articulations or different possibilities based on the will of an institution, the will of a family, the will of a city, the will of an individual. The way in which this plays out, I think, indicates to us exactly how, or exactly what defines the sense of liberty, of liberation, exactly what constitutes the individual side of the argument and what constitutes the more collective side of the argument. And regardless of the orientation of the individual thing, of the identity, of the principled identity, I think another thing that can be brought into here is both the state of things and man's state of things, which I think can be a subset of the state of things, but since man's way of perceiving the environment has a lot to do with his station, how his society prospers, and all this sort of thing. Now, within this state of things, within this way in which the mind perceives his relationship to himself, to others, to institutions. His ideas of liberation and of freedom, of independence in general, will necessarily follow from that. But the general spirit, the idea for which we think about an identity and its relationship to the broader identity, is what we are concerned with here. This is the spirit of the thing at hand. And the way in which one point articulates with another is contextual. Depends on the age. It depends on the progress of thought. And so I want to read this first clause one more time and then sort of give a closing statement. First, we have granted to God, and by this our present charter have confirmed, for us and our heirs forever, that the Church of England shall be free, and shall have her whole rights and liberties inviolable. We have granted also, and given to all the free men of our realm, for us and our heirs forever, these liberties unwritten, to have and to hold them and their heirs of us and our heirs forever. So, I focused on the church here, but I've also touched on the individual. And of course, the second part of this first clause is quite indicative of the individual's liberties. To all the free men of our realm, and to all of their heirs, these liberties underwritten. I may have said unwritten, but underwritten is what it says here. And so in closing, I suppose what I'd like to say is that this clause, and this goes to the critique of some of these clauses, that it is too vague, or that it does not specifically outline a liberty or a right, let's say. I don't think that's necessarily the point of these types of clauses. The point is that there is a general sense of liberty, that we have to come to some consensus, and we have to have an institution that facilitates that type of consensus. If it is overly top-down, or if it is flooded by a type of sense-making that will not allow us to see those intricate details, then we will necessarily be bound at the moment of what we would consider a liberty or a right to be. Or we just will not have the possibility or the ability to introduce a liberty into society because of some rigid structure that governs it. And so in closing, I see this first clause as a general statement, a confirmation of liberties, as the title suggests. It is not meant to outline specific liberties. It is much like in the American Constitution, or the American popular conception, that the Bill of Rights is not something that is an exhaustible list. The Bill of Rights is there, it has some fundamental rights, but it is not exclusive. There are many rights that are unwritten. And I think that if I did make that mistake in reading the first time, as opposed to how it is written, underwritten, in the first clause, I probably use the term unwritten because there is so much that can be written, but so much more that lies outside of the realm of deliberation in a particular moment that is considered unwritten, that would be, by the same token, considered within one's liberty. And it's a difficult thing to defend one's liberties in the face of so much interaction. and also in the face of that which we wish to conserve, because there are certain things that maybe one would call a liberty, being liberated from something, that we just cannot afford at our present juncture, our present structure of governance. And maybe it's something that we have to work towards if we value it. If not, then we have to make the sacrifice. So Clause 2. The relief of the king's tenant of full age. If any of our earls or barons, or any other, which holds of us in chief by knight's service, die, and at the time of his death his heir be of full age, and owes us relief, he shall have his inheritance by the old relief, that is to say, the heir of heirs of an earl for a whole earldom by £100, the heir of heirs of a baron for an whole barony, and by 100 marks, the heir of heirs of a knight for one whole knight's fee, 100 shillings at most, and he that has less shall give less, according to the old custom of the fees. So let's break this down a little bit. It took me some time to figure out exactly what they were mentioning in the first part of this. The relief of the king's tenant of full age. Now, the relief is a payment, which we'll get to. Now, the first part of this is important to understand. If any of our earls or barons, or any other of that nobility class or landowner class, which holds of us in chief by knight's service, So this is a contextual piece. What this is implying is that all of these people, the nobility class, if they are to be under the king's dominion, and they are bounded by a certain obligation, which we've talked about before, that obligation is by knight's service, then this applies to them. If they lie outside of it, then they don't have these rights, let's say. Whereas in the modern context, we might say a citizen has certain rights under law. We say that in this case, the nobility have certain rights under the king's dominion, or within the king's dominion under his authority. Now, this relief that is spoken of is a payment made to the king, or to the lord, by the heir upon inheriting that feudal estate. If any of our earls or barons, or any other, which holds of us in chief by knight's service, die, and at that time of his death his heir be of full age, a sort of legal, customary age, whatever that is, and owes us relief, he shall have his inheritance by the old relief being another customary relief, and then it lays out specifically what that will be. That is to say, the heir or heirs of an earl for a whole earldom by £100, the heir or heirs of a baron for an whole barony by 100 marks, the heir or heirs of a knight for one whole knight's fee, 100 shillings at the most. And he that has less shall give less, according to the old custom of the fees. So, I think what we can appreciate here is that this specific clause is not appropriate to our modern age. We don't live in feudal societies anymore, but there is an interesting historical context here, historical precedent, which seems to imply that before this is written, the purpose of having this put into writing, is likely because there was some abuse of the king. Perhaps that when an earl or a baron or a knight, any owner of land had died, the king probably just took that land arbitrarily. And it would seem to us to be a strange thing, after the death of a landowner, for his heir to then pay the king for it. But again, this is the nature of the relationship. And this is a much better relationship than an arbitrary taking of one's inheritance. So it's an early form of inheritance or a passing down of property, which in a way is a type of privatization, which is important for this idea of private property, of ownership. This outlining of the relationship between that civil authority and the class of the citizen. The wardship of an heir within age, the heir of a knight. But if the heir of any such be within age, his lord shall not have the ward of him, nor of his land, before that he has taken of him homage. Second, and after that such an heir has been in ward, when he has come of full age, that is to say, to the age of 21 years, he shall have his inheritance without relief and without fine. So that if such an heir, being within age, be made knight, yet nevertheless his land shall remain in the keeping of his lord until the term aforesaid. Okay, so let's break this down. But if the heir of any such be within age, now this within age, to me it seems kind of confusing, the language. The implication is that the person in question, the heir, is not old enough for whatever's about to follow, for the relief, or to inherit. But within age, I sort of think, if something is within something, I think of my pen, I think of the ink being within this pen. It is within the bounds of the object. But if the heir of any such be within age, and within age here, age being of the appropriate age, in this case, as we'll come to find that it is 21, that he is at least 21, then everything else would follow, but I don't think this is what it's referring to. It's being under the age of 21. His lord shall not have the ward of him. And having ward of him means some protective guardianship or legal guardianship of his property, whatever. But in this case, it's talking about him in particular, at least in this part of the clause. His lord shall not have the ward of him, nor of his land, before he has taken of him homage. So another sort of confusing usage of language here. It's saying that the lord or the king is taking of the heir that is not of age yet. Well, what exactly is he taking? Because homage is something that is given. It is something that is paid, a special honor or respect that is shown in a formal sense, a public acknowledgement of feudal allegiance. So this taking is sort of a taking of a guarantee in a certain way, a taking of a liberation, a taking of a certain type of, or certain sense, a certain degree of autonomy, such that the heir, this underage heir, is pledging allegiance to the Lord, so that this right that they are after, this sort of codification of law, again of right, of the idea that the heir will indeed at one time, when he comes of age, be the rightful owner of some property, under the king's authority, of course, under his dominion, within his dominion. So again, to reiterate, this homage is that formal ceremonial experience that guarantees the king will not arbitrarily take the land, because when that heir, it is demonstrating that that heir has some legal right to the claim of that land within the under the authority of the king. And it is because of that that he will be the guardian of it when he is of age, when he is of 21 years of age. And after that, such an heir has been in ward, when he's come of full age, when he's no longer under that guardianship, that is to say, at the age of 21 years of age, he shall have his inheritance without relief and without fine. So he will not be obligated to pay the king for that inheritance. It is given over to him. So that if such an heir, being within age, be made knight, while in this case this is being made being obligated to serve the king in some military exploit, yet nevertheless his land shall remain in the keeping of his lord until the term aforesaid. So another interesting legal description here. If this person is not of 21 years of age, and they are being propositioned by the king to go along with him, let's say, for example, on a crusade, he is made a knight, he is given a certain responsibility, maybe he is the officer of a certain number of men, he does not have to pay the fine on that future, on his future land, his future property, because he is still in that wardship of the king. Once that term expires, though, then he'll have to pay the fine, like a property tax. So in sum, this is certainly in relation to that second clause that we had just gone through, which outlines the or curbs the arbitrary authority on the part of the king that would cause him to take a feudal tenure arbitrarily from a nobility, a person of noble birth. The second is an extension of that. It still grants the king authority to hold land in absence of a person being of age. And it would be an interesting thing to think that in our modern day, if a child had lost their parents, that the state would hold that property until the child was 21 years old and then gives it back to them. I think many of us would understandably be quite suspect of such an agreement. But if this was something that did not exist prior, if, let's say, that if two parents died, that property would just sort of be left to the immediate overseer, the lord, the king, and it was not written, it was not an agreed upon custom that the king would return it to the individual, then it would put this idea of an individual right to a claim, or some property, some inheritance, in jeopardy. And so we have a formal recognition that even if a child is not, let's say, developmentally capable of managing a land and managing the people on the land, that there is this, at least in theory, or hypothetically, there is a process by which we will go through until he is at that age. The mind has developed to an age where he is now able to take on that responsibility. But of course, by taking on that responsibility and retaining that property, he'll still owe the tax. He'll still owe the relief to the king. No waste shall be made by a guardian in ward's lands. So this reads, the keeper of the land of such an heir, being within age, shall not take of the lands of the heir, but reasonable issues, reasonable customs, and reasonable services, and that without destruction and waste of his men and his goods. And if we cannot commit the custody of any such land to the sheriff, or to any other, which is answerable unto us for the issues of the same land, and he make destruction or waste of those things that he has in custody, we will take of him amends and recompense therefor. Third, and the land shall be committed to 2 lawful and discreet men of that fee, which shall answer unto us for the issues of the same land, or unto him whom we will assign. Fourth, and if we give or sell to any man the custody of any such land, and he therein do make destruction or waste, he shall lose the same custody, and it shall be assigned to 2 lawful and discreet men of that fee, which also in the like manner shall be answerable to us, as afore is said. So kind of confusing legal language, but let's see what we can make of it here. So again, the chapter of this, or the title of this 4th clause or 4th chapter, no waste shall be made by a guardian in ward's lands. So we have a continuation of the previous theme, that there is likely an heir that is within age, and the land is under some guardianship of a superior lord or king. The keeper of the land of such an heir, being within age, shall not take the lands of the heir, but reasonable issues, reasonable customs, and reasonable services, and that without destruction and waste of his men and his goods. So another fairly broad declaration here. Much like the spirit of liberty, this idea of reason, or that which is reasonable, much depends on this. Again, just as much depends on the idea of the liberation of the self, or of a particular class of people from the sovereign, or from some legal obligation. And I want to take the proverbial approach here. Just because it is broad doesn't necessarily mean that it is meaningless. It's broad, I think, necessarily because reason is itself something that is broad. There are many potential situations that can arise, and we have to use what we consider to be reason to work our way through the reason why a guardian of a land may take the lands of a particular heir. So let's talk about what is reasonable, so we have some principled way to move forward. We can consider reason in this context that it might rely on some other legal precedents, some other situations that have come up in the past, which helps us to a degree, but it doesn't help us address novel circumstances. Now, if there was some legal precedent in the past, something had happened in which it was found by some congregation of people that it was justified for a guardian to take the lands of an heir. Let's say, in a relatively obvious case, that the heir had died, and there was nobody else within that line to leave the land to. I suppose we can find ourselves in a way of justifying that that land would go to whoever was the guardian of that land. So that would be one example of a legal precedent. Now let's say that another situation had arisen. Maybe there's a crime that had been committed on the part of the heir. And without going into too much detail of some imaginary situation, let's say that there was a deliberation on this topic. The question in my mind becomes, well, how would the deliberation be conducted such that we would ensure that whatever justification that a person or a group of people had come to was what we call reasonable, and it would justify the losing of lands? And that's difficult. Like in many cases in the United States, for which we have this national news coverage. Right now we're currently going through the news coverage of the murder of the CEO of United Healthcare. And it seems to all of us that this is a fairly straightforward case, in case of murder. And it very well may be. The suspect has pled not guilty. And I'm not really making a comment on whether or not I think that it actually is truly not guilty. There are plenty of other examples. It's probably not the best one, but there are plenty of examples that what is exposed to the general public will be only an abridged version of what is exposed to the people in the courtroom, to the jury. And ultimately, that process is something that is designed and I think meant to facilitate reason and to better reach some judgment so that it's not an arbitrary distinction, so that there are not certain facts that are ignored or purposefully omitted, such that a person's the deciding on a person's guilt is swayed in one way or another. The completeness of evidence in a trial, I think, is fundamental to deciding, to coming to an appropriate understanding, a reasonable understanding for a particular outcome, a decision. So what is reasonable in this case, in my mind, is influenced by the way that we do decide cases. But what is reasonable, I think, is something that has come to based on the evidence. It's not arbitrary. It's something that follows some logical consistency. And by the merits of the arguments that are based on the information that is gathered, the judge or a group of people will make judgments based on that and decide. And so here, what we are seeing is the recognition that something like this has to happen, that there has to be a formalized process so that we avoid arbitrary abuses. And I think wound up within here is the idea, the desire for greater individual rights, greater individual autonomy. That value is shifting, that it is moving away from more of a collective understanding, collective identity, to more of an individual identity. And I think that this theme we will expand on as we go through these clauses, but it's quite an interesting thing to reflect on. And at this point, I'm not quite sure exactly how I feel about it. Of course, my mind is oriented in a particular way. I've been raised in a culture and with a particular frame. And it seems that the potential of man is facilitated given a degree of autonomy and personal freedom, personal property, and this sort of thing. To not have it, to not be exposed to it, I can only imagine that a person in such a situation, or if I was in that situation, it would be because my mind is captured. I am, my agency, my will is made subordinate to another person in a way that I would find intolerable. But then again, in the modern day, this I have considered to be the nominal age, and it's hard for me to say if we continue to live in a republican democracy. It's more of an oligarchy than anything, and whether or not my mind has fallen and been subject to arbitrary authority, I'm sure it has. I am locked and bounded by various institutions and that wish to control, let's say, perhaps by shadow, but still have influence and significant control over the value of money, rents, overall taxation by the state, debts, the organization of debts. It's a complex issue. Shall not take of the lands of the heir, but reasonable issues, reasonable customs, and reasonable services, and that without destruction and waste of his men and of his goods. So even if there's legal justification, they're saying that good wardship and good guardianship must continue, and that without destruction and waste of his men and of his goods. The second part of this, and if we commit the custody of any such land to the sheriff, or to any other, which is answerable unto us for the issues of the same land, and he makes destruction or waste of those things that he has in his custody, we will take of him amends and recompense therefor. So even of the ward, in this case the ward is the sheriff, if the ward is being irresponsible and making a waste of the land, whatever that might be, I'm sure there's plenty of things that we can come up with there that would satisfy that, then we, which is the other interesting part of this that I want to talk about, but we will hold the sheriff accountable. So there's always this sort of check on arbitrary abuses. But the we-ness of this I find fascinating. Now, I did some searching, and I was curious about the development of Parliament, and at the time of the Glorious Revolution in England in 1688, there were these debates that went back and forth about where power ultimately ought to rest, whether it be in Parliament or whether it be in the king, the sovereignty of the king and the monarch. and of common law, if we should rely on legal precedent for the how would I say this? For the development of law, for the standard by which we compare new situations, or by statute, or of a top-down written law on behalf of Parliament, or even on behalf of the king. But here, it serves as a good point to reflect on exactly what this "we" implies. It implies, as I've mentioned, a check on arbitrary abuses. But the check is only a part of the equation, because a check only goes so far as the top power structure. If Parliament is on top, then that's where it ends. Now, if there's a revolving system at the top, for which there's different institutions or bodies that are checking each other, then that would avoid many of these potential abuses. So I'll talk a little bit about the position of this sheriff, what his role was in the 13th century. So this is from ChatGPT. The sheriff was one of the most important local officials, serving as the king's representative in a county which was referred to as a shire. The role was a combination of administrative, judicial, and military responsibilities. So the sheriff was somebody that was appointed by the king, a member of the local nobility, or a trusted loyalist to the crown. Position often granted to those who had wealth, influence, and the ability to enforce the king's authority. The sheriffs usually held office for 1 year, but terms could be extended based on royal favor or political necessity. The sheriff was a powerful figure. He acted as an intermediary between the monarch and local communities. He was responsible for upholding the king's interests in the region. So getting into his specific responsibilities, the sheriff was responsible for tax collection, collecting royal taxes, fines, and fees. They delivered the collected revenue to the royal treasury, often via the exchequer. Law enforcement. They maintained law and order in their county. They pursued and arrested criminals, summoned jurors for trials, and ensured the enforcement of court rulings. They had a judicial function. They presided over local courts, including shire court, where disputes were resolved and justice administered. They assisted in organizing and enforcing the decisions of the royal courts. They had a military role. In times of war or rebellion, the sheriff was responsible for raising and organizing the fyrd, or local militia. Sheriffs also managed the defense of their shire, including maintaining fortifications. They had administrative duties. They oversaw the management of royal lands and forests in their shire. They conducted royal inquiries, censuses, and surveys. Organizing the assizes, sheriffs coordinated visits by itinerant judges, traveling judges, to hold court sessions known as assizes. They summoned juries and ensured the smooth functioning of these proceedings. Execution of writs. They carried out orders from the king, such as enforcing royal writs or summoning individuals to appear in court. So effectively, I think what we can say here is that the sheriff is an extension of the crown. Many of these responsibilities, the crown cannot administer, the king cannot administer himself in all the various shires. And so this is that royal extension. So again, reading this second clause, and if we commit the custody of any such land to the sheriff, or to any other, which is answerable unto us for the issues of the same land, and he make destruction or waste of those things that he has in custody, we will take of him amends and recompense thereof, or therefore. So what can be said here of the second part of this clause? Going off of that theme, that this is an extension of liberty to a certain type of selfhood. Now this is referring to the nobility, the class of the nobles. They are trying to secure a legal, lawful right of succession, that an heir, even if he is not of age, not capable of maintaining a land or some property, that whatever the keeper is, whoever this keeper is, there are certain restrictions placed on this keeper to preserve that successive right. And in the second part of this, there's another interesting relationship between this class of nobles, and I think we can extend this out a little bit, or at least the modern mind quite readily extends this out well past the noble class. Because what we are being asked to consider is that the sheriff, one of the lead representatives of royal authority, submit to a body of men, sort of a premature parliament in a way, this body of collected nobles. And if we commit the custody of any such land to the sheriff, so here even in that first part of that, and if we commit the custody of any such land to the sheriff, there's an implication that whoever we is, whether it be the population or it be this select group of nobles, they are saying that we have this authority because of this clause, because of this charter. If we commit the custody of any such land to the sheriff or to any other which is answerable to us for the issues of the same land, and he make destruction or waste of those things that he has in his custody, we will take of him amends and recompense therefore. Whereas before, one might imagine a situation in which the sheriff might be exposed to arbitrary abuses of power. The king may have allowed the sheriff autonomy in certain shires, in certain counties, and these abuses surely would have gone unchecked. That a keeper may have just kept the land and not waited for the maturity of the heir. And then, of course, the heir is without his royal tenure. So this image emerges between two power centers. Three power centers. One would be the church, one would be the king, and then the third would be the nobility class, the parliamentary class. At the very least, I think we can say that this distribution of power is now creating a check, sort of a check and balances type situation. If we imagine the three power centers, the church, nobles, and king, the sheriff is this extension of the kingly authority, and so the sheriff reports directly to the king's house. But now the sheriff also reports to the nobility, in the sense that the nobility are now, by law, enforcing that arbitrary abuses shall not be tolerated. And that if it is to be the case that an heir, if his properties are to be, or if he is to be a ward of the state, if his properties are to be kept by a keeper or this sheriff, then they ought not to be diminished in any way. The value of them ought to be retained. The lands in their acreage must be constant. Otherwise, the sheriff sacrifices something to the nobility. And by extension, the sacrifice of the sheriff would be the sacrifice of the king. Because if the sheriff is stealing something beyond his means, let's say a certain plot of land, then the sheriff would have no recourse except to his superior, which is the king, to pay his debts. The king is the surety for the sheriff. And of course, that relationship of the surety increases if there is a check in the body of the nobility. I suppose it's worth mentioning that at this time in England, 13th century England, during the reign of King John, he submits England essentially to the fiefdom of the Catholic Church. So it does a couple things. I've mentioned one already, talking about the liberty of the English Church. Of course, it submits the English Church to the Church of Rome, but also subordinates the sovereign, the monarch, to the Church of Rome, to the Pope. The third part of this clause, and the land shall be committed to two lawful and discreet men of that fee, which shall answer unto us for the issues of the same land, or unto him whom we will assign. So somebody that is discreet, somebody that is careful and observant, somebody that does not cause disruption. They respect the responsibility that is given to them. The first part of this I find interesting. The land shall be committed to two, not one, but two, lawful and discreet men of that fee. Of that fee, I think it implies that of that particular noble class. So if they are taking or claiming wardship over an heir, if it is an earl, then it's probably two earls, two people of that station. If it is a baron, two barons, etc. But this too lawful, I find to be interesting. For what exactly does it mean for this type of person to be lawful? In the original case, when we started talking about heirs, we spoke of this in the context of the king's lands, that the king is ultimately the one that is in charge of this enterprise, this society. And all of these ideas of relief, tenant, wardship, they all imply that the people that live on the land are subjects to that king. But the interesting part about this period in history and the shifting positions of authority, and by extension, where the power rests, what is considered lawful, in my mind, what comes to question, is this the law of the sovereign, of the monarch? Is this the law of the sovereign, of the nobles, of the church? Likely, it is a combination of all three, what is considered lawful here. In the most immediate sense, I think we can say that of a noble, he is considered lawful or lawfully of that class if he is approved by the king or appointed by the king, or by some other elevated noble that promotes a person of inferior rank. And so, yet there's this additional desire to produce checks against the arbitrary abuses. And by extending this from one person to two, what we have is the reduction in the possibility of abuse. The fact that they are lawful and discreet. Again, another introduction of the reduction in probability of abuse. The fact that these men answer to the council that is responsible for putting together this charter, that nobility class, that's not just one person that they are reporting to, but a group of people, again, decreases the possibility of abuse. Now, this really drives home the importance of the law in question, because these declarations are built on top of certain assumptions. Certain assumptions that the heir has a right to succeed his predecessor, his parent, the source of his value, let's say. And I think this can be extended out into any number of different ideas. It depends how fundamental they are. It just so happens that these people at this period have decided that this hereditary succession was quite important to the maintenance of their liberties, to holding on to their lands, holding on to the what little authority that they had in the kingdom. And in fact, I think this class of people wielded quite a large amount of power, and I think that this is evident in Henry III's reign after King John, in which the various discontented nobles get together, raise armies, and actually overpower the king's ability to enforce, and so they make the king submit to their demands. The problem that I see with this, that I found was evident earlier in this book about what happened in the 17th century, the arguments again about the position of the king versus position of parliament, and who has ultimate authority, which body is sovereign. That it's quite difficult in every situation to have this check. So these two people shall answer to us, to that noble class that is writing this charter, for the issues of the same land, or unto him whom we will assign. So ultimately, whoever is charged with this responsibility will report to this group of people. The fourth part of this. And if we give or sell to any man the custody of any such land, and he therein do make destruction or waste, he shall lose the same custody, and it shall be assigned to 2 lawful and discreet men of that fee, which also in a like manner shall be answerable to us, as afore is said. So the question, is this an improvement? I suppose to a degree it is. It doesn't solve the problem of potential abuses by that group, of course. But it does prevent the abuse of a very centralized form of authority. And I don't want to make this all about power. But again, referring to what I had spoken about earlier, about this way in which any particular body that we may consider as one thing, as having an identity, or having some agentic quality to it. What I see here is a furthering, a progression, or just generally speaking, a change in that relationship between man, or noble in this case, and the power center, or the king. Again, I wanted to get away from that word power, because I don't think it's all about power. It's about relationality, and it's about the flow of value. So, chapter 5, or clause 5, guardians shall maintain the inheritance of their wards, and of bishoprics, etc. It reads, the keeper, so long as he has the custody of the land of such an heir, shall keep up the houses, parks, warrens, ponds, mills, and other things pertaining to the same land, with the issues of the said land. And he shall deliver to the heir, when he cometh to his full age, all his land stored with plows, and all other things, at the least as he received it. All these things shall be observed in the custodies of the archbishoprics, abbeys, priories, churches, and dignities vacant, which appertain to us, except this, that such custody shall not be sold. So I think this law gives greater clarity to what we might consider to be waste. And here it's saying that this guardian is responsible for keeping up all of these things. And he shall deliver to the heir when he comes to his full age, all his land stored with plows, and all other things, at the least as he received it. Now there's a larger concept that I want to talk about here, and it has to do with private property. Private property leads into ideas of the individual, and how that individual is related to everything outside of himself, gives rise to this idea of individual and collective. This is a theme that I have talked about before, and it comes up again just as much as it comes up as the barons, the writers of this, the nobles in England in the 13th century, as they wish and desire to have a liberated Church of England. They also wish themselves to be liberated to a degree. And this process, this problem, this dynamic, is something that never seems to be solved. It is a balance that is perpetually tricky. It is a series of complex dynamics that I have to wonder if there's actually any real solution to. Are we bound to be like these, like various water molecules that are flowing from one container, from one style of institution to another, from one ontological container to another? So I want to try my best to outline something here that is productive. It's going to be going off of proverbial sensibilities. And the main thing that I would like to track here is exactly where this node, or where this historical event, but generally speaking, where these types of decisions rest within the mind. Now, what do I mean by that? I wonder, since we are talking about the barons preserving for themselves private property, that this keeper, they say, so long as he has custody, should keep up everything that is to be given to this person that is yet of age to inherit their property. He is meant to deliver it in the same state, in the same way, in the same constitution as it was when it was left to him, which means there needs to be a record of that at the time of death of the former, which means that this idea of having something that is private must extend generations. And I think that's sort of the point, regardless of what we are considering here, whether it be some matter of succession or of inheritance, or it be of the liberation of the English Church, or of some matter that is more personal, more valued, something that is considered more of a right of man in the common in the contemporary age, something fundamental. What is truly being passed down is our ideas. Now, eventually these ideas may find themselves some material manifestation, and I think that this land can be seen this way, or some aspect of material property, and we could say that this idea amounts to something that is the desire for power. We could say that this is of many different inlets, ideas on the part of somebody that holds something. And since we are thinking about succession, thinking about multiple generations, I think this level of thinking affords us a particular type of prudence with regard to subsequent ideas. And since we have a longer view of things, the ideas, I think, themselves become longer. They become more sophisticated. But again, this idea, the foundational aspect out of all of man's purposes, out of all of his desires, he formulates things into these images, into these purposes. For what reason may be uncertain at the time. Perhaps, much like the landed property, what is passed down is the reason, is the purpose for their accumulation. And one would hope that when a king inherits the throne of a kingdom, that he has in his mind some idea of where he has been, of who he is, and of what he ought to do so that good things occur. Seems kind of straightforward and simple. But these good things, a whole life's worth of understanding can go into this sort of recognition, of learning, of experiencing, of feeling, of losing. Okay, so that in mind, how does this necessarily relate to private property? Or, in this case, since it's not, that right is not distributed among everyone, and this private property is, among a certain class, keeping that in mind, we can say the state, or what we have here is the ensuring of a particular type of ownership, a state of ownership. Now, it's private in a sense. It's private in the sense that there's an aspect of a community, of a group of people, of one person, that desires to be disconnected from another entity, another agent in a way, another type of collective agent. And I think there's various levels that we can see this. We can see it first at like the many institutions view, in which there are many different institutions that are communicating, articulating with one another. In our day, it's perhaps easier to see this sort of thing than back in the days when this was written. But at the time this was written, despite the common man not necessarily being a part of his own experience in a way, of course he has his own experiences. Agency may be limited by the institutions of the age and by his ignorance. That's not to say that the Middle Ages were an ignorant period, but I say this to say that in the 13th century, we have a few primary institutions. We have the church, we have the civil authority, the king, the monarch. We have what we can call a parliament. We have the commons, if I haven't mentioned them already. And then there's this interrelated web between them, although they maintain this separate identity. they all participate in the same thing, that is the Kingdom of England. So the uniting factor for this whole thing to survive, the whole structure of classes to survive, they must agree on their being in England. So there's something that must be sacrificed, I think, from each of them that guarantee or maintain that state. Now, among them, it's apparent that they are sacrificing certain things to ensure a certain type of state. And state in this sense, I don't necessarily mean government. The way in which it can't be, but the way in which I'm thinking about it is the state of the individual mind, the mind of a particular baron or noble, such that this noble can pay attention, can use his own ideas for his own ends, for his own purposes. Now, those purposes may be good, they may be bad, it's unknown. So I mentioned that we could see this more at the communal level, or many institutions level, or from one individual to many individuals, or from the nobility and then the sheriff. Again, that the king's, the extension of the king, one sort of finger of the king, if we will. Whereas we say the hand may be the underlying bureaucracy that supports that institution. It supports the monarch. That could be the various individuals that are responsible for gathering taxes, the individuals that adjudicate, that provide sentencing for crimes. They are the enforcers, well, not necessarily enforcers, justices, the judiciary, elements of the judiciary that hear cases and prosecute, make judgments, all this sort of thing. And so we have this massive institution that is taking from the people and then feeding them what is considered to be right, what is considered to be wrong. And we have another parallel institution, which at once can be seen as something separate, because it is, but also it can be seen as something that is quite intimately related, in the sense that the archbishoprics, the abbeys, priories, churches, the people that are heads of these various institutions have a type of authority, institutional authority of their own, which has a bureaucracy that is subordinate to it. And these two forces intermarry. There can be checks between them, but there can be religious authorities that, certainly in the days when they are subservient to the king, they sort of form the bulk of his bureaucracy. Now, there's a way in which I think this is a bit off, and it's not necessarily exactly that way, but nonetheless, we have another institution, if we can call it that of the parliamentary institution. It is the institution of the nobles, the noble class, the barons, who increasingly at this time see themselves not as something completely subordinate to the king and all of that bureaucracy, but something that is separate, because they have a wealth and an authority of their own, and they wish to enact their purposes and not be completely burdened by the tyranny of the king, in their view. And we have the commons. The commons upon whose backs all of this can exist. And that's not to say that there may not be a righteous king at one period, or a nice cultural sway that it gives such a vibrant display that people are happy to stand up and take the burden. That's possible. But I have to wonder about this period, if it was one of those. And I have to wonder, given so much reference to the before the Norman conquest, that there were these ancient liberties that were practiced among the Saxon tribes, that perhaps there was something about the way in which they had done things then that was better for people in general. And that's not to say that the people of the 13th century remembered exactly what they were. It's possible that they did, of course. But the way in which the Magna Carta is written is not an explicit reference to a law of a particular old Anglo-Saxon king. Perhaps the ideas, the sentiment, the spirit found its way to them somehow, but it's hard to say how it was at that time. Now, I think that gives enough of an image to understand exactly the various interplay, the various institutions and identities that we are considering when we are talking about breaking the individual from them. Now, there's another image I would like to introduce. It's sort of like it's a TP, a mental TP. Outside of that TP, we can think about any concept we like. Within the TP, it's a particular concept, particular idea. Within the TP is where our attention goes. Along the base of this TP, we have many individuals, we have commons, we have people in general. On top of them, we have the formation out of their minds, again inside of this TP, the formation in their minds, various ways of integration. The integration actually holds much of the value, or it facilitates, rather, much of the value. There's like the infrastructure, or the vessels through which purposeful and meaningful information flow and find its way into the material world. But this concept that we are considering is the idea of England. And within this TP, it is all of the various subcomponents of what that identity is. And in what I've just mentioned about these various different things, the commons, the barons, the nobility class, the parliamentarians, the king, the church, and perhaps various threads from without, from the papal see, from the French society. My apologies for the break in the Constitution, but today's a new day. So picking up where I left off with this TP analogy and thinking about all of these different elements that are within it, all of these elements are interrelated factors that participate in the identity of what is considered to be English. Regardless of what it is, whether it be the monarchy, the baronial class, the ecclesiastics, the commons, all of them participate in the same identity. And so there is this necessary thread among all of them, unless, of course, the identity is dissolved. Sort of anarchic, chaotic situation comes to mind. But within this identity, what I find interesting is the interplay, is the way in which we see here the baronial class wish to be separated from their sovereign. They wish to rediscover, or cynically to take for themselves, certain liberties, certain rights. All the while, that principal identity, that which binds them all together, sort of spiritual, mystical thread in a way, it contains within it that judgment. The judgment that decides on matters of identity, I suppose, or boundary, or transgression. And the extent to which this TP can tolerate difference will determine, I think, at some level, the relationship, the level of individualism that is possible to maintain this unity. Now, of course, we know how the story plays out, and it's a rather interesting thing to reflect on now, in the modern day, about exactly what we've become and where we are going. But nonetheless, I think we should keep this TP analogy moving forward. I think it's going to be quite useful to come back here to orient ourselves. So I think I'm going to end this episode here, and I'm going to continue next time, picking up with Clause 6. I've been calling them clauses. They might be called chapters, but either way, I'll keep with the Clause 6.